And the only prescription is more cowbell.
I'm broken system, broken trust, and I approve this message.
For legal reasons, that's a joke.
I need that money. I really, really do. I need that money. I really need that money. Really need that money. I need that money. I really, really do. I need that money. I really need that money. Really need that money. Really, that money. That money.
Oh, shit. Here we go again.
We are back. We are live, as some meth gremlin would say. Sorry I was late. I was actually, hold on. I was actually messing with that said meth gremlin in another chat. He's not having a good day. So, we are here to watch a sovereign citizen do something really scummy. And I'm seeing it more and more, and it's again scummy. A sovereign citizen showing up to court, trying to sovereign citizen his way out of, I believe it's child support. Yeah, so he's going to try to weasel his way out of child support. Pickle KFARR is my favorite KFARR. That has been said by other people, I'm not going to lie. All right, 19 people here. All right, yeah, we did 2 streams yesterday. I had to stream last night, if you guys didn't catch that. I streamed with Boot last night because Chris said that a clip that I keep showing is AI. And if you guys know me, I don't know shit about AI, so it definitely can't be AI. Morning. All right, let me pull this up. We're just going to get into it. I'm going to play it at, I think it's like 1.5 or 1.15 speed, 1.2. Because it's like 30 minutes long. This guy's an idiot. 34 minutes long. My apologies. All right, here we go.
Okay. And, sir, can you state your full name for the record, please?
Yeah, I'm Zahir Dean, the living man.
And this is from the channel Judge Reacts. There's not really much reacting.
Okay.
But
and Mr. Dean and Ms. Baskins, can you both please raise your right hands to be sworn in? Again, a few housekeeping items. The first is I am an associate judge, and you do have the right to a de novo hearing before the referring court regarding decisions I make. That being said, Mr. Dean, you wanted to say something?
Yes, thank you, Judge. Judge, I'd like to say I'm here on special appearance. But first, we were here last time, and I was really sick, and I wasn't able to speak, so I appreciate you giving me the time to recover and come back here today.
That's better. I
am looking for a dismissal of this case due to due process violations. I was not given proper notice, and in the notice, I wasn't given a clear statement of the proposed actions. I wasn't given the specific reasons or grounds for the proposed actions, including a description of the facts and evidence upon which the actions based off of today. I wasn't given sufficient detail so I can understand what is at stake and what.
Now, I don't want to spoil it too much. Don't want to spoil it too much at all. But I got to make myself bigger. Dear Lord. I can barely even see myself on the screen. Yeah, so I don't want to spoil it too much, but this is going to come into play for this part, and there's like a second part of the hearing after this that took place, I believe, on a later date. It's very important. There we go. That's better. Because he was notified. And they make it abundantly clear of how he was notified, and he brings it up now, gets told how he was notified. The judge says, okay, yeah, that's perfectly okay to notify him that way. And then in the second part, I think it was a week or two later, he tries the same argument, and it's like typical sovereign citizen shit.
I need to contest or respond to. I wasn't given information about how to access the procedures for responding or contesting the actions, including contact details. So because of this, I'm requesting a dismissal of the case, Your Honor.
And just for clarification, sir, have you filed anything requesting this relief?
No, because I don't know what's going on.
Okay.
I don't have any information. Was not noticed properly, given the proper notice. And because of that, there's no way for me to proceed.
I offered to email them to him this morning. He was served back on June 10th by side posting and so on his door. He was served.
Objection. Is there evidence to prove that, Your Honor?
So I'm looking for the service return
Yes,
right now.
actually.
It says on June 10th, 2025, it was posting the citation to the front main entry door per Texas Rule 106.
And I do take judicial notice of that executed service return.
So that was just a preset, but this is also the motion to confirm and the motion for substituted service was all served on him.
Oh yeah, it's multiple. Yeah, the 3 pages in that service return.
If I've got an objection on that, Your Honor, it says it's been posted on my front door.
At the front main entry door is what it says.
Yeah.
Yes.
I did not receive that, Your Honor.
Okay.
So now he's claiming he didn't see it on his front door. Didn't see it on his front door. I'm gonna let me word this a better way. It's pretty easy to serve someone, especially if you know where they live. If you know where they live enough to post it to their front door, more than likely they've tried to come into contact with you a few times a different way by giving you the paperwork. So more than likely this guy was like fucking looking out his window, making sure the coast was clear, making sure the process server was at lunch, making sure the sheriff's deputy was at lunch, whatever, and then just ran to his car and dipped out. Yeah. Oh, facty. Yeah. In a nutshell, you broke the law. Now you're in court. Wake up, living man. No, he's too dumb. Too dumb. Can't do it.
I've got an objection to that.
Yes, I do believe you've made an appearance in the case. So, sir, you're claiming right now that you don't have a copy of the pleading. Is that true?
I've got an objection to that as well, Judge. So when we were here before, I did have a means to communicate with the clerk prior. However, during the Zoom when we were speaking to you, I did not have a means to communicate in terms of chat for me to object to that. But now I'm able to speak. I agree on a reset to come back to figure out what's going on here, but my objection still is for due process not having a sufficient amount of information.
And I'm willing to take a short reset. I can email him the pleadings. I've offered to do that before, and if he needs a chance to look them over.
Yeah, and I've got an objection to that, Your Honor. Due to the due process violation, I'm requesting a dismissal.
Okay, sir, this is not a...
No. You're not going to get a dismissal. Sorry. Especially after they say, yeah, you know what? We've actually offered to email this to him before, and he said no. And now they're just like, I don't want to say mom and popping because that's not the exact thing, but they're basically saying, oh, you didn't want to do it when we were just talking in private. But now that we're on the record and the judge is right here, I'm going to let you know that I tried to do this earlier just to get you to look bad in court, and I love it.
Well, I'm finding it's not a due process violation. You are here. People are allowed to make appearances before the court. You've made an appearance before the court multiple times now. I'm not dismissing this lawsuit. It's a matter of making sure you do have a proper notice to proceed, though, in fairness. And so I do want you to receive a copy of the pleading so we can proceed. I do believe last time, Ms. Khan, because I thought this case involved a modification and confirmation. I believe last time Ms. Khan, correct me if I'm wrong, I think it was this case, corrected me and said this was just a confirmation of arrears. We're just confirming arrears in this case. Could be all sorts of things. And I want you to have your day in court in fairness. But I am denying the request to dismiss this action. I don't find this been a due process violation. Have you provided Ms. Khan information, a way to send you a copy of the pleading so you can review it?
Your Honor, I've got an objection on the appearance as well. I'm not here or have I ever been here on general appearance. I've always represented myself under special appearance.
I don't know what that means, sir. Are you not a person?
I am a living man.
What does that mean?
I am a man.
You are a man. I'm a woman, but I'm here. You're here.
I'm here as a living man representing my person.
We get it. You're the living man. You sound dumber than dog shit. Obviously, you're the living man. If you were the dead man, you probably wouldn't have been to court. They probably wouldn't be hounding you for this money because you're dead. See how easy that is? Hurts my brain. Because Tom. But you're pretending to be dead Tom.
Myself.
Under what legal basis are you doing that?
Under constitutional law.
I'm finding you're here and you're making an appearance, sir. I don't know what law you're referring to. If you'd like to cite a specific statute or a specific part of the Constitution, I am open to reading it. But my understanding of the law is you're here, and there's no legal representation of yourself in that form. So I would like you to receive a copy of the pleading. I'd like you to review it. If you need additional time, I'm even open to resetting this to the December.
apparently we're buffering. We're buffering today, guys. I've been having problems with the internet all day today. So if my stream randomly dies, we're getting storms from like now until tomorrow. So be aware of that.
11th date, I'd rather not. But in fairness to you, if that needs to happen, I will give you a little more time.
That would need to happen, Your Honor.
Okay, thank you. So you did receive it?
I did.
Confirm.
I did via email.
Okay, do you want to review it now, or do you want some time to review it before we proceed?
It's a pretty long document. Yes, very long document. I'll definitely need time to review.
Okay, and just so you know, despite the length of the document, we will be proceeding to final trial on December 11th, 2025. No more resets. Mr. Dean, can you state your full name for the record, please?
Yeah, I'm the man here of the Dean family, and at this moment, I would like to say that I'm here on special appearance, and I don't consent to any agreements, or I don't give up any, and I don't waive any of my rights.
Right now, I'm just swearing you in, and we'll get to your special appearance in a moment. I understand you want a hearing and don't agree to anything. Ms. Baskins, can you state your full name for the record, please?
Yes, it's Adrienne Baskins.
Okay. Can you both please raise your right hands to be sworn in? Mr. Dean, is your hand up?
Oh, yeah, sir.
Okay, thank you. Do you each solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
You can both lower your hands. And counsel for the Attorney General's office?
Julie Kahn for the Office of the Attorney General.
Okay. Mr. Dean, did you file anything about a special appearance?
I did.
You did?
I did.
Would you know about when you filed it?
I filed it yesterday, Judge.
It has not made it.
So because I've been dealing with Chris Ryder for like the last week, why is it that these dipshits always try to wait until the last second to do anything court related? Oh, I need my records for court tomorrow? I guess I'll get them today. Right as they're about to close. This guy, oh, when did you put that in? When did you submit that? Oh, yesterday. Like, you knew you had this and you did it yesterday? Weird.
To the court file is Ms. Foote. Do you see it? Is it in the documents?
No, ma'am, I don't, but I will check e-file and see if it's in there.
Did you electronically file it, sir, or did you walk it?
I did. I e-filed it, and I've got an, I can get you the envelope number.
You've emailed it to us. Is it the affidavit of truth?
Yes, I emailed it to you as well.
It's meaningless.
In addition, I e-filed. I've got an envelope number if that would help. Would the clerk like the envelope number, or?
I don't need it. I can check by the case number. I'm checking right now. There is a demand letter as the description. It has not been accepted. I'll get it accepted right now.
Thank you.
And Judge,
It's been accepted. It should come up in the system in just a few minutes.
and Judge, you mentioned you're coming outside of Montgomery County. Specifically, where are you coming out of?
I am in Harris County, and I'm doing this pursuant to the Family Code 201.1045. My clerk is in Montgomery County today.
Judge, it is in the file now.
Showing. Let me click on it.
Judge, you might need to go out of the case, then come back in.
I found it in the documents tab, so I think I can pull it up that way.
Okay, thank you.
I'm going to take a moment to read this. Mr. Dean?
She took a minute to read it. But yeah, that's exactly what I'm talking about. But Your Honor, I filed the request 1 minute before they closed the day before. What do you mean it's not in your records? And then everybody's saying it's all a delay tactic. Yeah, I can see that. I mean, look at what Chris does. Chris has been delaying a case for fucking almost 2 years, I feel like, by just doing dumb shit like this. No, I believe this is a child support thing.
Why don't you proceed on your pleading? Though I'm going to say I don't believe this is timely, but you can explain to me why it is.
Okay. So, Judge, so all of the times that I've came to court, I've always mentioned that I'm under special appearance, and the sole topic.
Means to you?
Yeah, so I actually had the definition from Black's Law Dictionary instead of
Official.
Instead of giving you my interpretation of it. All right. So under Black's Law Dictionary, it says special appearance is when a defendant appears in court solely to contest the court's power over them without submitting to it, often called limited appearance. General appearance is basically when someone comes into court accepting the jurisdiction and so forth.
Okay, so can you explain why the court does not have jurisdiction over you?
Yeah, so because civil procedure was not followed under Rule 107, that identifies that the court doesn't have jurisdiction to proceed with a judgment because the civil procedures were violated.
Would you like to flesh that out more, sir, or do you want to leave it at that?
And you mean in terms of
what you're saying?
So basically,
how was it violated?
Yeah. So there's not a return to service that was filed, and specifically in the affidavit, I've listed out the Rule 107 for return of service. That's the requirements for it, and that was not followed. Because that was not.
Can you specify what part of the return of service was not followed?
Yes.
The return of service on file. So which of those many rules you listed out did not happen? Or should we go through them one by one?
So there's not a return to service on file, Your Honor.
There's an executed citation, a constable return of service and citation. It was filed with the court, I believe, June 16th of 2025.
Was that under e-file?
It's in the court file. I'm not sure how it got here.
Is Mr. Dean done? Is it?
Yeah, Mr. Dean, are you looking at something, or is there more you'd like
No,
to say?
I'm sorry, Judge.
Okay,
I'm sorry,
you're looking at something. I wanted to give you time to look for what you needed to prepare.
Oh, okay. I'm sorry. I thought I was waiting on you. I thought you were doing something to where.
Then I was just waiting to see.
Okay, so the document you're looking at, Judge, that you're saying it's on the court files.
In the court file, yes.
In the court file. So I'm not seeing that under e-file. And when I looked up that information, there was.
Are you in research? What system are you using to look up information? Because it's possible it's just not there because it's not the official court file.
Okay.
But I don't know what you're looking at. Ms. Khan, are you able to see it in your accesses?
I can share the screen, Judge, if you would like to show where he was served. I think we did this last time too, though, at the last hearing, and we acknowledged that it was service by posting on the door. He said he didn't get a copy of it, and so I emailed him, and he acknowledged on.
So this is what I was talking about. This idiot, this brain dead moron, is trying to claim again in another hearing, well, but I wasn't served properly. After the judge already ruled that, yeah, bro, you were actually served properly. This is like, in my opinion, let's see something similar. When sovereign citizens like to try to play the, oh, well, I'm just here to dispute jurisdiction. Even though at arraignment, when they tried to do the jurisdiction thing, the judge proved to them that he had jurisdiction. It's the same thing. Everybody said it earlier. It's a time waster. It's a time waster.
The record that he had received it, and so we've already.
Yes, Judge, and I had an objection to that. That's not return to service under civil procedure.
Is there anything else you'd like to say, Mr. Dean?
Ms. Khan was saying that she was going to share that document with us.
I mean, I feel like we've already covered all of this, but
we haven't. The last time we were here, we did not see that document.
You may pull it up, Ms. Khan, so you can see it.
This is the second page. First page is just the citation, and then this is where he stated where he left it.
So I was speaking to Ms. George, and she is stating that this is part of the citation. It's not the return to service.
I'm sorry, who's Ms. George?
She is the child support case representative, Tanisha George. So this document is the actual citation, Your Honor.
According to the child support officer.
Yes, ma'am.
Ms. Khan, is there anything you'd like to say in response to his allegations?
Judge, he was served by substituted service, and it is newly on file. There was proper motion filed, following the rules of civil procedure, and also his issues with saying that he had not received a copy of it. He has since received a copy of it, accepted that copy. So at this time, I would think that we should be able to move forward.
And I've got an objection to that, Your Honor. Procedure is not followed at the very beginning. There is no reason for a judgment because the civil procedures was not followed initially, according to Rule 107.
And Ms. Baskins, is there anything you'd like to say?
My understanding is we're just confirming arrearages today. I'm not sure what the trouble is.
Can you please stop sharing?
Yes, Judge.
Okay.
I'm sorry.
So, but we do have open courts in Texas, and if we were live in the courtroom, anyone could come and watch it as well. So this is how the people who make the decisions have deemed we comply with that provision. Okay, I am denying the special appearance jurisdiction over you, sir. There's a prior order in this case, so I do find jurisdiction is proper and the return of service on its face is valid. You may proceed, Ms. Khan, with the motion to confirm arrears.
Yes, Your Honor, I would offer the pay records. We have two in this case. There's one from the Harris County cause number and then one from the Montgomery County cause number.
I'm just going to point this out. Yes, you have to have a job to have your wages garnished. You have to not get paid under the table, you know, at random ski lodges, yada, yada. So, garnishing wages sounds great, but people like this will go out of their way to find a way around that. And there's going to be someone dumb enough to try to help him.
Share the screen.
You may.
Mr. Dean has been sent copies of these today via email.
Okay, wait, before we share screen, does anyone have any objection? I'm confused as to, since the case was transferred here, I'm confused as to why there's two pay records. But Mr. Dean, what is your legal objection?
I have an objection. I was here under special appearance, and I'm prepared to be here under special appearance. Now that the court is transitioning this to a general appearance, I'll request time to prepare.
So you were given time last time to prepare?
Under special appearance, Your Honor, and I did.
But that has been denied. This case was filed November 27th. We're already after over a year.
Right. So you've denied it today under special appearance. Now that you've denied it under special appearance and it's a new appearance under general appearance, I'm requesting time to prepare under general appearance.
Ms. Khan, do you have a response to that?
Judge, the case is already over a year old. I have a feeling that it will be dismissed if we don't go forward today.
I've got an objection on Ms. Khan's feelings of being dismissed as not evidence.
Ms. Baskins, is there anything you'd like to say?
Right. I mean, this is like our fourth or fifth time to reset this. I feel like the matter at hand, simply confirming arrearages, is we're not arguing about anything else. I feel like it's pretty straightforward.
I'm going to deny your request, sir, and we're going to proceed today. We're going to begin, and just a few housekeeping items. I am an associate judge. You do have the right to a de novo hearing before the referring court regarding decisions I make. As I said earlier, nobody should be recording this. There should be no audio recording, video recording, or broadcasting. Everyone should be speaking in civil tones, which you are doing, so thank you for that. And we generally take testimony, so one of you will be asked questions at a time by the AG. Since you're both representing yourselves, you'll both be given a chance to speak as well at the end. And then just be aware.
Yes, that's exactly what he wants. He's trying to just keep kicking the can down the road. Keep kicking the can down the road. Until, yes, they eventually dismiss it. That's what I don't like from most courts. I streamed it yesterday around the same time as I am right now. Yesterday, sovereign citizen got held in contempt for arguing in bad faith. I believe every single sovereign citizen should be held in contempt for arguing in bad faith. Like this. Oh, well, I was here. I prepared to be here in a special appearance, not a general appearance. Eat a dick. Contempt. Have fun in jail for 30 days with your friends. Like, if you play games, you're going to end up in jail. That's how I think the court system should work. If you have, speaking of BSBT, because it seems to be relevant to him, if you have fucking 5-6 pretrial conferences, you get one. Under special circumstances, you get 2. 5, 6, 7. No. Have fun in jail. That way we can get you when we're ready.
Aside from things that have been said before me, I don't know what you all have discussed in the back or on calls with the AG's office, so just be aware I'm not with them. So you might be asked questions or things that you've discussed previously. Just be aware that that's how I do get the information. And so does anyone have any legal objection?
I've got an objection, Your Honor.
Okay, what is your objection? I'm asking that what you're objecting to. Yes. My question was, does anyone have any legal objection to the pay record or the pay records that Ms. Khan is attempting to admit?
I've got an objection to it, Your Honor. So Ms. Khan is a third party in this case. The case is between the state of Texas and myself, and I'm wanting to know, Ms. Khan is a third party submitting evidence. Is the state of Texas submitting any evidence as well?
I'm sorry, is the state of Texas doing what?
Submitting evidence. It's 2 separate entities, Your Honor. Ms. Khan is with the Attorney General Office, and according to the communications that they've been sending, they are a third party. And the case here today is between myself and the state of Texas. I I'm wanting to know, is the state of Texas providing any evidence, or is Ms. Khan providing the evidence?
I don't think you understand. Ms. Khan represents the state of Texas. The Attorney General's office is part of the state of Texas. And I'm overruling your legal objection. Do you have any legal objection to the?
But I do have another objection, Your Honor.
Lay it on.
So the second objection is that if we're going to move further with the case, I'm requesting a trial by jury.
Okay, that has not been timely requested, nor are you guaranteed one in this case. So I'm denying that request.
I've got an objection to that, Your Honor. Since we're moving forward with general appearance, I'm requesting a trial by jury because this is a new appearance, and I'd like to get time to prepare for a trial by jury.
Ms. Khan, do you have any response to that?
Judge, in Texas, a jury doesn't determine issues related to child support.
Yeah. What is the jury issue? I'm not sure a jury would hear a confirmation of arrears.
So I'm just objecting to exercise my right.
I would argue that child
He's
support.
just objecting because he has the right to object. That's what he's trying to do. That's literally what he's trying to do. And it's bothersome to me. Because let's be honest, if you're sitting in a jury, which is wild that you got picked anyway, but if you're sitting on a jury and a dad comes in and says all this sovereign citizen bullshit, and then says, oh, I've never paid child support for my children, I would immediately find him guilty. Sovereign citizens and frauditors and mores are well known to be hated by juries because they're dumb assholes. So the fact that he's saying, oh, I want a jury trial. No, you don't. No, you don't. You're a sovereign citizen. You don't want a jury trial. Everybody's going to think you're dumb, stupid, and just playing games.
Is a legal issue and reserved for the court and would not be an issue for the jury.
I don't object to that, Your Honor. Is there evidence to that statement? Is there a rule, a law to that statement? Or is it just Ms. Khan's opinion?
It's Judge's Family Code Section 105.002 lists the issues that may or may not be sent to a jury. And it does say 105.002C2 states that the court may not submit to the jury questions on the issue of support under Chapter 154, child support, and several other things, but that's the one.
Thank you. And I'm finding this request not timely. Based on 105.002, this is not a jury issue, and it is not a timely.
Yeah, I'll even make this even worse. I guarantee he'd be found guilty of owing child support within 2 minutes. KTZ, you just have to accept the way that I've accepted it, that we will never be able to be on a jury. The people who want to be on a jury will never, ever be on it. But no, yeah, they would say, all right, we're going to let you guys deliberate for a hot minute and then come back and they're going to be like, nah, we're good. He's guilty. That's what it would be. They wouldn't even bother to get up. They'd be like, nah, he's guilty.
Jury request must be made in writing. This is not in writing either.
Muted.
And so, does anyone have any legal objection to the pay records being admitted into evidence?
Your Honor, I know that you're going to proceed from now on, but for the record, I'd like to state I do have an objection for the rest of the proceeding.
Overruling your objection. Ms. Baskins, do you have any objection to the pay records being admitted?
I do not, Your Honor.
Okay. I'm admitting the pay records into evidence of States Exhibit 1 and 2.
And at this time, I would call Mr. Dean. Mr. Dean, can you state your name under?
Yes, I am the man Zahir Dean.
And do you understand that y'all had a divorce decree in Harris County? Is that correct?
Yes.
And then it was transferred to Montgomery County, and y'all got a new order in a suit affecting the parent-child relationship that changed the amount of child support. Is that correct?
Yes.
And for whatever reason, that order didn't combine the arrears from that prior order from county. And so today we're looking to combine both of those together into one number. So instead of 2006-1062 and 12,353.91, we combine it under one cause number so you don't have two different cases to pay into. Then it would be 14,964.53. Are you in agreement with that?
I don't know what you're like. I don't know the details of what you just said.
Okay. So do you understand that y'all had two different cases? Y'all had a case in Harris County, the divorce decree, correct?
Right.
And then you came to Montgomery County, you transferred the case, and then you had a new case that changed the child support amount a little bit for the Montgomery County case, correct?
Right.
And you've seen the pay records I've sent to you and I've shared them on the screen. Do you have any dispute that the pay records are correct?
In terms of what I've been paid at work?
In terms of what payments have been made towards this case?
And the information that you've shared with us earlier on the pay records, can you pull that directly from the child support account under the Attorney General? Okay. Yeah, that's the tool that they've used to garnish wages.
Okay, so are the pay records correct so far as you know?
I haven't reviewed it, so if that's the tool that they're using for the pay records, then that's the tool that they're using for the pay records.
Have you made any direct payments to mom, giving her cash instead of paying through the OHUs?
No, I'm court ordered not to. I'm court ordered to directly pay for the Attorney General's tool.
Okay.
Any payment towards mom directly would not be considered a payment.
Okay. So do you have any reason to dispute the numbers that we're saying that should be combined together into one judgment?
I do have an objection based off of being here today based off of the initial rulings from my objection.
But you don't have anything to say about the numbers?
No.
Ms. Baskins, I think you're on mute. Can you state your name?
Adrienne Baskins.
So today I'm just trying to combine the arrears. I want to confirm the child support arrears as of November 30th for $14,964.53, medical support arrears for $1,601.81, and the dental support arrears for $159.98. Are you in agreement with all of that?
Yes, ma'am.
Right, I pass the witness, Your Honor.
The state does not represent either of you, so I'm going to give you both a chance. If there's anything additional you'd like to say that you think I need to hear about the arrears and what the state is requesting. Ms. Khan, why don't you do a quick summary, because I think you have one already of what you're asking for, and that way everyone will know exactly what you are asking for if they want to object to it or contest it.
Yes, Judge, we're just asking confirm arrears as of November 30th, 2025. Child support arrears would be the amount of $14,964.53. The state would ask for a payout of $100 a month. Medical support arrears of $1,601.81.
Slow down a little so everyone can follow that.
Medical is $1,601.81, and the state is asking for a payback of $20 a month. And then the dental support arrears of $159.98, and we're asking for a payback of $10 a month towards that.
Okay. So, would you like to respond to that request?
Yes, Judge. I've got an objection. I saw the Attorney General's data for the actual child support, but I did not see the supporting evidence for the medical, dental, and so forth at this time on how that number came about.
Ms. Khan, would you like to call the witnesses on that issue?
Before they talk about that, where is it? Where is Ace's Dumb Criminals? Somebody can put Ace's link in the chat. So I'm trying to not be specific and be specific at the same time, so bear with me. So when I worked where I worked, we would regularly get people from Detroit. People from Detroit like to get a bunch of warrants and a bunch of child support because they know Detroit won't ever pick them up. So we would get somebody breaking the law where I worked in the next city. We'd pick them up and bring them to jail, book them. And once we fingerprinted them, it would go out to MSP. MSP would send back everything about them. The numbers, you guys think 15,000 is bad? That's like a drop in the bucket compared to some of the shit that I've seen. I've seen $80,000, $90,000 in back child support on a guy that also has 10 warrants out of Detroit. So, I mean, like, I don't even think suspending their driver's license would necessarily even help, because more than likely they would just keep driving. And then they wouldn't show up to court, get a warrant, and then it'd all be fine because they're never going to get picked up for it. Like, for a normal person, that would totally work, but not where I was at.
Oh, I can just answer the question. It's based off of the 2024 order that the parties had entered into. I think that
I don't know if it's I can take judicial notice of the order, including page 20 of 29. Orders Zahir Dean to pay Adrienne Daniel Baskins as child support the amount of $318.80 per month for the cost of health insurance, with that first installment being due and payable on August 1st, 2024, and a like installment being due and payable on or before the first day of each month thereafter. So that's where the cash medical comes from. And the dental support starts on page 21. And there's a paragraph on page 22 that says that here Dean is ordered to pay Adrienne Danielle Baskins as child support the amount of $30.95 per month for the cost of dental insurance. And then it continues with that same, if that helps. I take judicial notice of that 2024 order. And you may continue, Ms. Khan. Since I had it up, I figured I would help you there.
That would, and then it's also reflected on the same pay record that we had already discussed.
So I've got a clarification that needs to be made, Your Honor.
Okay.
So when you say that I needed to pay that, right, is it under the impression that it's going to be pulled under a garnishment of my paycheck, or?
I'm going to stop for a moment and say I am not on the witness stand, but I'll give you just some general information. When child support is due, it is due. I believe there's even a section in here that says it's all due and owing. I usually, if I'm setting child support, have been known to give a speech something like this. You are responsible for making your child support payments. Generally, the AG's office will issue a wage withholding order. If you don't have the AG's office in your case, usually a private lawyer will issue a wage withholding order. But you are ultimately responsible for the payments, not that wage withholding order. And so what I always encourage people to do is to look at their paychecks, look at what is due, make sure the full amount, especially when modifications happen. Often things don't happen quick enough. I don't know why. It's not always the AG's office's fault. Sometimes it's the employer. But for whatever reason, it doesn't always quickly happen. And so people need to look at paycheck stubs and look at what's coming out and look at what's due.
Oh, Lord, you guys kill me in the chat. So we've got this one. That's hilarious to me because, like, they knew they had back child support. You know what I mean? Years ago, I stopped a truck with a hooker in his truck. He was suspended 17 times and had $32,000 in support owed. Not shocked. Your brother is a deadbeat who owes $30K. And yes, Jeremiah Payne owes like $100K, but his doesn't count because he's too busy freedoming. He doesn't have time to raise a kid. Accurate.
And pay anything extra that's not due. Not everyone works for a company where you can withhold. Some people have jobs that they have to make not direct, they have to make payments themselves through the SDU, where that wage withholding order is not effective and they're not relieved of their child support payments. So I'm not sure if that answers your question or not, sir, but ultimately, however the payments get made, they're supposed to go through the state disbursement unit and you're supposed to pay them.
And it looks like we had someone join in, Wendy Cordova. Oh, she just jumped back on.
We're open courts, so people are here for all sorts of things, but they are all participants or with the AG's office. Ms. Baskins, is there anything else additional you think I need to hear?
Not at this time, Judge.
And Ms. Khan, just to clarify, because that was up pretty fast, the amounts that were due under the Harris County order, they stopped once August 1st came around of 2024, I believe it is.
Yes, so
there's no double dipping?
I think it looks like it even, yes. Last one was April 30th, 2025. Well, oh no, I see it. July 1st, 2024 was the last time we billed for that one. And then I believe.
And then this starts up on August 1st of 2024 for the Montgomery.
Yeah.
Okay, so
yes, the last time we billed in was July 1st, and then it switched to the other one.
Okay, I'm going to confirm the child support arrears based on what I'm going to do, Ms. Khan.
18 months, Wixom. Dear Lord, thank you. And yes, this is giving me Chris Ryder vibes. How dare someone join the living man's sovereign court case? They didn't even ask him permission to drive on the main road of his city. How dare they?
I'm concerned about interest, and I'm not sure what will happen. So I'm going to confirm the arrears in the Harris County cause as of July 31st of 2024.
Okay.
Here in Montgomery, though, so that you can enter into your system the judgment as of that date, and then the Montgomery numbers will just roll from there. Because I don't want to.
It's actually higher, which is weird.
Because some payments were made since then, or?
Yes, there were payments made since then.
That's okay. So those payments will still accrue, and it'll all go down. Correct?
Yeah.
Okay. And so as of. Did you understand? So what I'm going to do, sir, I don't want to possibly double dip on interest. I don't think it's a doubling, but I do think mathematically this will be less interest in the long run. I could be wrong.
40 months. I can't even do the math on how long 40 months is, but that's a long time. I appreciate you.
But I think I don't want to compound anything. And so I'm just going to confirm the arrears that were due based solely on the Harris County order that is now transferred to Montgomery and is here in Montgomery as of July 31st of 2024. So that will be the starting of the pay record for Montgomery now, is whatever was due under the old order. And then anything new that accumulates or gets applied will get applied, all combined now in that order. So anything you've paid to either causes since then should continue to apply, correct, Ms. Khan?
Yes.
Okay.
So
what is the number as of July 31st, 2024 for?
12679.31.
Okay. I'm going to confirm the child support judgment as of July 31st, 2024. There was no Montgomery County obligation at that date, so there's no confusion there. So the judgment against Mr. Dean in the amount of $12,679.31 as of July 31st, 2024. I'm ordering that he pay that back at a rate of $100 per month, beginning January 1st, 2025. Step ups as child support goes down. So the child support's going, let me get those numbers.
Go up to 1994. What is it? Child support.
2 children. There's a step down.
Oh, yeah, there is.
So the first one is 18,949.
Yeah, I was going to bring this up. Children are not cheap. I forgot how much this guy owes. I think you guys said like 13. 13,000 is a lot of money for kids. 30,000 is a lot for kids. Like I was talking about, 80, 90,000 is a lot for kids. Jeremiah, 100,000 is a lot for kids. Imagine the things you could get for your kids. And he just said, nah, fuck it. Oh, member for 7 months. Thank you, bud. But yeah, like imagine how many things they could have. They just don't care. He just wants to be a deadbeat.
Until paid in full. Does that make sense for drafting?
I think so.
Okay. And so the state's going to draft the order based on my ruling today, and they'll be circulating it to y'all through DocuSign to review and sign off on, and then you'll be free to go. But thank you all for coming in, and good luck with everything going forward.
Hey, Judge, what I'd like to do is once she sends it through DocuSign, I'd like to print it out and actually sign it in my own handwriting.
Should we set this for entry?
We can. And did you want to bring it in person?
Oh, I guess I can just email it back to you.
You have that capability to print and email back today?
I do.
Okay. I guess we don't need an entry date then?
I mean, if he doesn't sign it by today, I'm probably just going to submit it with it.
Okay. So you can get that done timely today? Because if it doesn't get returned to the AG's office, she'll just submit it in the way she sends it to you.
Okay.
Okay. So we're going to stop the recording and let these people in who are waiting. And
okay, that's it. That's the end of the case. Even at the end, he's trying to just be ridiculous. Another squid says, one nice thing about watching these, you can rest assured knowing that no matter how big of an anal pore you might be, you're not as big an anal pore as Mr. Dean. That's what I look at for sovereign citizens, frauditors, and the people that I cover. Anytime you're having a bad day, you can come to my channel and go, yeah, my life's not as bad as that guy's. Or, oh man, like I got fired from my job. I'm having a bad day. You look and you go, oh, well, that person's living out of a box and doesn't think the United States has jurisdiction over them. Could be worse. So yeah, I always do that with a certain, meth gremlin where I go, man. And then I look at him and go, could be worse. Could always be worse. But that's it, guys. I'm going to get out of here. I plan on making a video for this channel, a video for the third channel. And I was planning on streaming later, but I don't know if that's going to go through. We're supposed to get a whole bunch of storms starting in a little bit here all the way until tomorrow. So I don't exactly want to start a stream and then it's shut off because of weather. And then me have to sit there and fuck with it for the rest of the day. So I'm probably going to cancel that. It's the Chris Ryder in court thing from a few weeks ago, I think. But yeah, stay tuned. It'll be out at 5:30, the video that I'm doing. So it's a good one. He reminds me of Glenn Serio. But that's it. Everybody have a great rest of your whatever day this is. Bye.
still here? It's over. Go home.